Hello, everybody.
The Superior Court for the Harvard Judicial District is now open in session. The Honorable Peter Figueroa presiding. Good afternoon.
Good afternoon, everyone. May we have the appearance of the parties, please?
Yes, Stephen Stanley for the petitioner, Your Honor.
And for the respondent?
Your Honor, David Yale from the Attorney General's office.
Thank you very much. Before we proceed, I just want to advise each of the parties. It's helpful to the court, actually it's absolutely necessary for the court to only have one person speak at a time. We're doing this virtually, and if both persons speak at the same time, not only the record, but my ability to comprehend each party's position becomes severely limited. So I ask your indulgence, and each of you will get a fair opportunity to express and explain yourselves. So I ask that. This matter has been set down for a hearing on a motion which was filed, a motion to dismiss. There are written responses by each of the parties. I will allow the petitioner first to state his support for the motion that he filed on, I believe, June 9th, 2025.
Your Honor,
Actually, it's your motion, right, Attorney?
correct, Your Honor, filed May 27th.
Right. Okay. Please proceed.
And Your Honor, I'm willing to do a presentation on the motion, but it would basically be repeating what I had written. And unless the court has specific questions, I'm entirely willing to rely on my brief.
I've read it thoroughly. It's very short and very straight to the point. So I will defer then to Mr. Stanley, who's also filed a response, which I am looking here. Okay, opposition objecting to the your motion to dismiss. Please proceed, Mr. Stanley.
Thank you, Your Honor. I filed a motion to object to the defendant's motion to dismiss. One, he's never answered my complaint. He's stating that this is a duplicate from the filing before. I'd like to make it very clear for the record and for the defendant, this filing, as now in the numbered paragraphs in my complaint now, paragraph 3, which he fails to ignore. This is being denied access to the court, citing, I'm going to spell the case law, DUGAR versus COUGHUN, 613 F SUPP 849, 853 S.D.N.Y 1985 cannot be denied access to the court. The defendant keeps stating, and even in his brief, he says that he said to the court in his brief here that one, it was a court marking that I was being denied. He says that he repeatedly told the court in the last time when it was filed that I don't need that the court responds to it automatically. I have a signed sworn affidavit from the court clerk of Rockville Court and Hartford Court that says all court markings must be called in and marked ready by Tuesday or Thursday. If not, they are set aside and you have to reclaim them. You have a court clerk sitting in your courtroom today that will basically confirm exactly what I'm saying. So therefore, again, I cited that endless case law. If you look at my motion on page 2, he's bringing up, I'm going to spell the word again, Your Honor. It's in the law dictionary, AD/HOMINEM. He's attacking the opponent's character rather than the opponent's argument. So he's bringing up all my other cases trying to manipulate this court. I've listed endless case laws. I've looked it up. I went on ChatGPT this morning again, and all these case laws still state really clearly that they don't have any immunity. He's being sued in his individual capacity, going outside his job description and job authority. He was acting under color of law, and he went outside his job description and job authority. So therefore, again, the Supreme Court, the Supremacy Clause states really clearly, Marbury versus Madison, 5 U.S. 137, and it even states federal laws and Supreme Court cases apply to state court cases. Then it goes down with when a liberty interest is present, minimum requirements of due process are established by federal law, not by state statute. So therefore, again, Your Honor, he has no immunity because he went outside his job authority, job description, taking the law in his own hands. Therefore, again, to deny me my right for that legal call, which it was put in DOC timeframe within 24 hours, and it was done verbally plus written, and I have the documents. And therefore, again, this person failed to give me my legal call for one, court marking, as well as a legal call. The last time the court got manipulated from the Attorney General saying, well, it was a court marking, so they respond to it anyways. That is not so. That is a bold-faced lie. That was penalties of perjury under court law. So therefore, again, we refiled this again. We're not attacking the same thing. On paragraph 4, now we're attacking, he denied me access to the court. The United States Supreme Court, I got case law endlessly that says you cannot be denied access to the court. So therefore, again, this defendant took the law in his own hands, went outside his job description and job authority. Then if you look at the defendant's motion, he says that I need the state's permission. I'm not suing the state of Connecticut. I'm suing this individual in his individual capacity because he went outside his job description and job authority, violating that color of state law. So therefore, again, there is no immunity, Your Honor, when you take the law in your own hands. And therefore, again, I don't need the state's permission to sue them in their individual capacity. His motion to dismiss, he doesn't even list, if you look at my new filing, I took that back, it's paragraph 3 and the numbered paragraph, and it says in handwritten, it says, denied access to the court in the case law that I cited is even in the original brief. So therefore, again, you cannot deny me access to the court. No motion for summary judgment can be granted when, especially when there's merits and facts of a prima facie fact in dispute. And therefore, again, the dispute was, again, Your Honor, that it was denied access to the court. This warden, I even have a signed statement from the warden stating that that counselor never even reached out to the warden if they have to go as far as getting the court permission from the warden to reach out for permission. It is a counter supervisor. This Kim Such was a counter supervisor. And again, she denied me my right for a legal call, which is violating my constitutional rights of liberty of access to the court. So therefore, again, with a prima facie fact, I would even like you to bring to your attention on a prima facie fact, it's cited Chevron, and that's D.C.20543, and the new number S.22.451 and 22.122.19, 467 U.S. 837 1984. This overturns the Chevron at the United States Supreme Court, and it says that you cannot rely on the defendant's argument. It must rely on traditional oversights, laws, and discovery into the hearings and facts of merit. So therefore, again, it cannot rely on any hearsay. So unless you have a document to show me that you granted me that legal call in a fair time frame, you violated my constitutional civil liberty rights of access to the court. So therefore, again, there's merits and facts in dispute. So therefore, again, no motion to dismiss can be granted when he doesn't even address paragraph 3 of me being denied access to the court. He brings up again of the old claim of me wanting the request for a court marking. So again, this is additional to with denial access to the court, which has been refiled as a new claim. So therefore, again, it is not the same claim, Your Honor. Therefore, again, no motion can be dismissed when there's merits and facts on the record. And that word I cited to you before, he's bringing up all my other cases instead of relying on the merits of the case. He didn't even go as far as filing any type of pleadings, answering the complaint. He's just trying to rubber stamp this again. And therefore, again, my civil constitutional rights were violated by not having access to the court. And the Supreme Court says I cannot be denied that for no circumstances, Your Honor. Thank you.
Mr. Yale, with regards to the complaint that was filed, or at least I have it dated 4/21/25, how is this not a separate claim from previous claims that the petitioner has brought before the court?
Your Honor, it is the same. His prior case alleged that he was not allowed to mark cases ready. and that denied him access to the court, resulted in his case being dismissed. That's the same thing he's arguing here. It's the same underlying, as far as I can understand, it's the same underlying case.
No.
And Judge Gordon originally looked at this, and I cite to that Stanley v. Such, the Lexus number is 2023 Con Super Lexus 2295. It's in my brief. And he looked at all these issues, and he found that in the underlying case, the court actually did look at these pleadings and did consider the pleadings. There was no denial of access, and also that under the standing order in that court, which I believe was Rockville, the DOC cases, they don't have to be, motions don't have to be marked ready by the inmates. So this issue has been looked at. It's been decided by Judge Gordon. He said that these pleadings were considered, and I don't understand if the pleadings were considered, how that can lead to a denial of access to the court. He got exactly what he wanted, which was access to the court.
If I may respond to that, if I may briefly. Thank you, Your Honor. Again, I had 5 cases today. I marked them today. And if you listen to your answer machine in your court today, from Tuesday to Thursday, the recording says, and I marked 5 cases today, and it must be called in and marked ready, or if not, it gets set aside. So again, Judge Gordon was misinformed by this Attorney General. No motion, Your Honor. You got the court clerk sitting right in front of you. You have the laws right at your leisure. Therefore, again, no markings will be marked ready unless you call it in. Where he comes off saying that, I believe, is a penalty of perjury. Nobody ever said that the court are automatically marking for inmates. That is a bold-faced lie. I'm telling you that on the record. And if he says it again, I want this court to hold them in penalties of perjury, because all inmates must call their motions in and mark them ready, or if not, they are set aside and they don't get heard. So therefore, again, if the court don't give them to me in a timely manner, I am unable, and I have to reclaim them endlessly, which I've had by mail purposes. So therefore, again, that's the mailbox rule. Now we go back to where this new case, the last markings was Judge Gordon granted it, said it dismissed because he believed them about the court marking, which is a bold-faced lie, and I will endlessly take that to my grave. So therefore, again, I recited this, and this time I put access to the court, and I put the case law that says, and this case law came from Judge Gordon's brief that said if I was being denied access to the court, I would have a valid claim. So this brand new claim is arguing that he denied me access to the court, all right, besides the other claim of the markings. And therefore, again, your court alone will stand behind that all court markings must be marked ready. No inmates, because you're in jail, are they're automatically marked. And if you want to say that again today on the record, I would boldly grant you to say that so I can get the transcript to hold you for penalties of perjury, because that is a lie under Connecticut general statute. Thank you, Your Honor.
Thank you. Court thanks both parties for their presentations, and court will issue a ruling forthwith. Thank you very much, everyone.
Thank you, Your Honor.
One more link we have to lock in on, Madam Clerk.
Be safe, be well, sleep sweet, and much love.